Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina and today's topic, what's trending? Understanding what to expect in M&A antitrust enforcement in 2021. As detailed in our 2020 year-end review podcast, 2020 was no question marked by the COVID pandemic, but antitrust, consumer protection, and privacy enforcement remained robust despite of, and indeed in part, because of the COVID pandemic. 2021 will no question be yet another year of robust enforcement and will be marked by new leadership at both the DOJ and FTC. Today, we focus our attention on what we can expect in M&A antitrust enforcement in 2021. Joining me today is my co-host, John Roberti. Hi, John.
Hi, Christina.
So what are we talking about today?
Christina, today we're going to take a relatively deep dive into what we anticipate the trends will be in 2021 for M&A in competition law. It's an area where I think, for many of us, it's such a critical part of our practices. And I think there are interesting things on the horizon.
Great. And why is that important, John?
Well, again, M&A is the engine for many of the practices of our group. It's also a very important function that the antitrust agencies play. It's through these mergers, they give guidance about how they're thinking about competition law and understanding what trends are coming up. What are the key issues are going to be really important for our practitioners.
And who's our guest today?
I am absolutely delighted to tell you that we have Ilene Gotts. Ilene is a partner at the Wachtell Lipton law firm, where she's been a leader of their antitrust group for many, many years. But importantly, she has been a chair of the antitrust law section a number of years ago, and most importantly, a mentor and friend to so many of us in the antitrust bar. So I'm just absolutely delighted that she's here. She is, in many ways, I think, one of the deans of the competition M&A bar.
Great. Well, without further ado, Ilene, welcome to the program.
Thank you. Delighted to be here. Thanks to both you and to John.
Ilene, it's a delight to have you. But let me start with a very open-ended question. What do you see coming in 2021?
I'm glad I get to speak only about 2021. Because that means the crystal ball doesn't have to be that far into the future. I'm going to be speaking on assuming right now that legislation has not yet passed that could totally change the landscape, and that we really don't have new leadership in place. So I don't have to guess who the leadership is and what impact that would have or anything else. And I see some continuity in what we saw over the last year. I think we've had some pretty good sense of what's going to happen, and we can get into further detail. But I think we're going to have an extremely busy year on the M&A front. The pandemic put certain things on hold. We had a slow summer, but then a lot of deals start to being announced in the fall, and it seems to be picking up even additional fuel right now.
Yeah, I mean, Ilene, we're hearing that there are record numbers of filings coming into the agencies. Now, that doesn't necessarily mean that there are, interesting competitive mergers coming on the back of that. But I do think I tend to agree with you. I think that we're going to see increased activities. What do you see as some of the key areas that are going to be substantively important in 2021?
Well, I think we're going to see a continuation of the focus on wanting to understand high-tech mergers and wanting to understand, you've heard the term killer acquisitions and reverse killer acquisitions. These are ones where you have a firm that is fairly well established who's buying a firm that has maybe a product in development or is very nascent in their competition. And those raise really tough questions. It's where you are trying to anticipate what the counterfactual world would be. What would happen if the deal didn't happen? versus what happens if the deal does happen. And the standing point that acquirers, the transaction parties, are usually saying is this deal will actually be pro-competitive because we take the ideas of this nascent company and we add the resources and our wherewithal, and 2 + 2 = 5. And so the staff, when they look at this, are saying, is it 2 + 2 = 5? Or is it really that this firm would have otherwise been a thorn in the established acquirer's side? And so these are really difficult. So that's one area that started in the prior administration over the last few years, and with the attention on the Hill and everything else, and the lawsuits that we've seen with Facebook and Google, looking for the next Facebook out there, the next Google out there, and whether these deals will cause that. So that's one area. Other areas kind of related would be looking at healthcare, pharma mergers. These were areas where, if you look at the commission, when we had 3 Republicans and 2 Democrats, where there were constant splits as to whether the pharma policy and the way that for over a decade we've looked at these deals, whether that's changing. And so we might see some play there. And the third one I'll just throw out for right now is the area of vertical, where we saw really some increased enforcement in the last 3-4 years. And I think that will continue at both agencies.
Let's go back to the idea of what you I think described as killer acquisitions and the concept of nascent competition. What do you? We have seen that as a theory that's been talked a lot and a lot of excitement. Have you seen that issue coming up frequently? Or is it the type of issue that's interesting, where the agencies are going to be looking for cases to try to make some law?
I think the answer is both. Part of it is we don't really yet have a lot of empirical evidence in this area. It's something that is interesting. Anything that sounds digital, anything that sounds like it involves data or innovation, those are all areas that are now platforms intriguing to the agencies. And so whenever you have those, there'll be a stop and pause, and let's look at it. At the end of the day, will there really be problems in most of these deals? Probably not. I think they will still be careful in which ones they bring. But you just see in the last 2 years, these innovation sort of themes playing out outside of those territories as well, when there are new channels for distribution. When I think to myself, consumer products, something as basic as a razor, okay, whether it's a men's razor or a women's razor, and all of a sudden you have the Harry's and the Procter & Gamble Billy, both which the government took enforcement actions on. And it was looking at the direct-to-consumer marketplaces. With the pandemic, we've seen more of that. We might see it in healthcare. So those are just some examples of where we've already seen some action, and I think we will continue to see it.
Yeah, and you mentioned healthcare. I think one area where killer acquisition issues might come up is in pharmaceuticals, where you perhaps have a drug that's very early in its development, and there would be a concern that somebody was another company that wants to acquire that has a drug in that space may just kill it on the vine. But that's an interesting segue, I think, to the healthcare issue. I think, given where we are with the pandemic and the new administration came in and some of the issues that have been raised, I think healthcare is going to be a very important issue in 2021. Where do you see some of the differences, the cases that might not have been brought in, say, in 2020, but could be brought in 2021? Where are the touch points?
So I'm glad you actually brought that up, John. I've been doing this for 35 years, and sometimes I think that nothing really is new. When I started out the FTC, we were focusing on potential competition in the pharma area. It was looking at pipeline activities, innovation markets, and the like. Dick Rapp and I wrote an article, must be 20 years ago, roughly, that looked at where there was that attempt to predict what the impact of these two not yet out on the marketplace, let's say gene therapy drugs. What would happen if you put it together? And the parties were arguing, well, if we put it together, we're more likely to have a successful one. And the government said, no, you have to divest one of the two. And it turns out that at least back then, almost always the FTC got it wrong. And the other, even though it went into the hands of someone else, it did not work. It gets into this difference between type 1 and type 2 errors. And I think pharma is one of those areas where I'm not sure there is something broken to be fixed here. When you look at it, there really are, and it's the one area where you actually do have a sense of what the competition is doing. So the idea that there might be someone that's doing something in development that the agency doesn't know about is much less. But I actually do think this will be an area where you will see concerns. Maybe the one thing we did learn in those prior cases is it might make a difference who ends up being the divestiture buyer, but even there, it was not clear because all the divestitures were done to really well-established pharmaceutical development companies, and yet almost always it was only one, or in some cases, neither of them actually came out with the new drug. So I just think it's worth not thinking that this is that unique, and before you start enforcing in a different way, going back and seeing what we can learn retrospectively by what happened in the past.
Very, very interesting stuff. And in sort of the adjacent area of, say, hospital mergers and providers, the agencies have been pretty active. Do you see that continuing? Do you see that increasing? Where do you see that going?
I definitely think we'll continue seeing that. There's a long tradition for the FTC to bring hospital merger challenges. For a while there, they were losing. In the last decade, the success record's been a lot greater for the agencies winning it. I think we'll also see it and part of this is you might have seen the article a couple of weeks ago where the FTC's studying transactions that involved physician practices. And a lot of times hospitals are now affiliated with physician groups. And so looking at that sort of dynamics and understanding, so it's not just hospital mergers, but whole systems and what happens when you put it in. In a city like New York City, it's not going to have a big impact, right? There's lots of choices. But in smaller areas, what happens if all the anesthesiologists are somehow involved in exclusive arrangements? Could that make a difference when there's a combination of the two? A couple of the cases that the agencies have brought involving hospital mergers in the last decade, maybe the last 5 years, have involved some of those vertical questions.
And that's again a good segue to another area that I'm interested in and that's vertical mergers. Now, in the last year and a half, we have seen some developments, some new guidelines and commentary and things like that about the agency's focus on vertical. Do you see anything changing in 2021 on vertical?
I actually think this is fascinating because we've seen in past situations where it's a changeover in administrations and a whole new party goes in. One of the things that is on the agenda for that administration is immediately to throw out some prior guidance or statements, whether you talk about the Section 2 guidelines or even the remedies guidelines. Here, I don't think that's going to be the case. With the commission having been split 3-2, like they were, when the vertical guidelines came out, there was first a draft and then there was a final, and there were certain compromises worked in. For instance, getting rid of the quasi-safe harbor that had been criticized by the two FTC commissioners who happened to be Democratic. So I think there already was moderation on a lot of that. The commentaries were just talking about what's out there. And so what does this mean? I think it will be very low priority, and I might end up being wrong because I don't even know who's going to have the positions, but very low priority to actually take the time to rewrite the guidelines or the commentaries, but instead it will be in how they are applied. They're in closed cases, the way they are written right now, it can go either way. So there's no need to redo the guidelines. Instead, I truly believe we'll just see a very aggressive enforcement agenda involving vertical transactions as far as at least investigating them and maybe beyond. And in connection with that, those vertical transactions, this also applies for horizontal. If we see what's happened in other administrations that involve the Democrats, I wouldn't be surprised if we didn't see, as part of the merger investigation, a review of the company's business practices. What are their business arrangements? Do they have exclusive arrangements? Do they have most favored nations provisions? Or are there non-competes? We get into the labor area. That all kind of plays out in the non-competes. And out of that, some of these investigations can take a life on their own. Now, I'm not just saying it's just because there'll be a change in administrations. Even this prior administration, you think of the tuna case, and out of the tuna mergers, the Bumblebee one, we ended up with criminal indictments. And I'm not suggesting that we're going to have criminal indictments out of any of this, but I think we will see sometimes that would be another area, the vertical restraints area, that grows out of the merger review process.
Ilene, you mentioned there the infusion of other policy objectives into merger review. I think we've started to see the beginning of that with some of the speeches by Acting Chairwoman Slaughter, and just some discussion about the need to make competition law benefit other policy goals. What do you think? You mentioned some of them. You mentioned the labor. What are some of the policy goals that you think might get injected into merger analysis?
So we're talking about what enforcers might do, not what I believe they should do. And I want to actually address both. I'll pretend I'm queen for the day or something in part of this. I actually think, first of all, we operate under a consumer welfare standard. That's a pretty broad standard. I remember hearing from the Commission, the European Commission once, the statement that employees are consumers too, and so we got to care about wages and other things. That was 20 years ago, I heard that, and I thought, wow, that's pretty outrageous. But you can use that consumer welfare standard and really put into it whatever you feel you want to within certain parameters and still be there. I think we've heard about racial equity, diversity concerns, income inequality coming up, even some of the what we call broadly as the ESG sort of governance issues, climate control. All that is something that possibly could get into effect. Privacy concerns, how much they get looked at, investigated, and thought about. All that is really fair game. At the same time, do I think that's the way it should be? No. These are the antitrust laws are a blunt instrument for addressing it. Just like when we look at foreign investment, absolutely fine for us as the United States to decide we care about some of those issues, or for any other place with direct foreign investment laws to decide as part of industrial policy or the greater interests of the country. But does that mean that it should be included as part of the antitrust analysis, that people who are antitrusters as part of their review under Hart-Scott or otherwise should be injecting some of this? The more we move away from what we're good at figuring out, more the economic policies, into the more objective, more of the subjective, I should say, policies, the more difficult it becomes, and the more likely we're going to get it wrong.
The national investment, we see some of these non-economic factors come into play with non-US regulators. I think sometimes through not necessarily through their competition law, although in South Africa, for example, I know that labor is an essential element of the merger analysis. But you also see it come through in industrial policy, in different foreign investment laws and areas like that. What do you see happening in 2021 in that space?
I will include in that outside the United States, because that's where we had as our export starting in the 1980s, the whole idea of pre-merger notifications and reviews as part of the competition laws. We have had CFIUS in place since the late 1980s. In the last couple of years really, but really in the last year, we've seen a increased interest by other countries in using and being concerned about foreign direct investments in their countries as part of their national security concerns. And then some of this even goes into issues of domestic supply of food and medical products and all that. There's some of this that you can understand and being justified. Again, it's more appropriate that's outside of the competition authorities that they do that, but understanding the competition policies. So it's likely that we're going to see that being a major concern, and something that when we're doing deals, we should step back and think, have we really thought out whether there's going to be an element of filings with the French folks who deal with labor, or the German folks who might be concerned about you're buying some factories, concern about jobs being lost, and Black empowerment, which is what you're mentioning. It goes beyond labor in when we're dealing with South Africa, has been in place for about 20 years now. So there can be a role. And I'm just questioning whether that role really should be within the what we do as competition lawyers.
Fair enough. And let me take you from the international then back to the United States and ask you about the role of the states. I think the states will play an increasingly important role going forward, particularly in 2021. In the non-merger space, there is concern that the FTC will lose its power to seek disgorgement, and if it does, one of the solutions is to bring states along and to have states use their powers to try to get that sort of remedy. On the merger side, do you see a role for the states? Do you see the states being as active as they were in the last few years, where they at times went it alone? Without the feds, or do you see the states perhaps working more in tandem with the federal government, still playing an important role, but maybe going less frequently going on their own?
In the merger area, I think we will see more working in tandem. They'll keep their resources to be not to replicate, but to be listening and having a seat at the table, because I do believe there'll be very good working relationship between the federal authorities and the states. And so they'll probably, my own sense is, be able to, by just sitting there and talking with the agencies, be able to make sure that their viewpoints get really considered. And they'll spend more time, because there's going to be a lot more follow-on litigation in the high-tech space, focusing on the conduct litigation and cases, in which actually would not be surprising if they feel at the end of the day that they will get compensated for it if there's damages and other things in that. In a time of scarce resources, and all the states are going through that also right now, just putting it in there, where we might think antitrust is the whole world. But when you look at the budget of the states and you look at what the cost of COVID has been and what is likely to continue, antitrust is just one part of that. If you can not have to divert resources from the other, or maybe not even thinking you're diverting. It's the higher priority items that you want to use more for medical, COVID, whatever it might be. We're going to have people unemployed. We have businesses that are in trouble. We have landlords who are in trouble. All these other items are likely to be even more important to the states than replicating what the agencies are doing on merger review.
And let's talk a little bit about timing as well. This is very helpful. Thank you, Ilene. Let's talk a little bit about timing, because there are a couple of things that made 2020 very, very challenging. One of them, obviously, is the pandemic, and there will be some timing issues, and who knows when those issues will get worked out. The other has been 2020 was a year of political evaluation and then change, because we had an election, and ultimately now it looks we are going to have a new set of enforcers coming in. How does that play out as you look as you look ahead to 2021? How does these timing issues play out in M&A evaluation and getting the mergers through?
When we went to that little slow spot, that was right in probably May or June, where we thought the world was over as far as M&A deals went. I started to work on writing articles, thinking about doing something to look at distressed entities. What happens when you have not just a distressed entity, but a distressed industry, etc. And then things seem to have settled down, right? And we got, as you said, a record number of deals in the fall that were filed, but they weren't the flailing companies, by and large, defenses. I'm not saying there weren't any of them out there. There were some. We might see, as this continues to be a prolonged pandemic, we might actually see maybe some situations where the companies run out of fuel, and where we will see whole sectors possibly wanting to combine so they have the scale to deal with the new world that they're facing. And in all those, when you look at it, and I'm trying to think who it was, which of the commissioners wrote I think it was actually Commissioner Wilson who actually talked about what you try to figure out in these particular situations. Is this just a temporary thing that we're facing? Or is this now a permanent change in the structure of the industry, the desirability of it, et cetera? And so that's going to be where that is the crystal ball that's harder to read when we go forward in matters involving distressed industries. We were talking about nascent competition, just trying to predict what the but-for rule would have looked like for that firm operating alone. Well, when you take it into the distress thing, you're also trying to read what would the standalone basis be. Is it that there'd be the failure here? So that's what I think we're going to see play out, probably not in the first 6 months of 2021, but as we move toward the end of 2021 and maybe into 2022 for those firms or those industries that ultimately are unable to continue to weather the impact of the pandemic.
One of the things that I think will be interesting about 2021 is it may get off to a little bit of a slow start, because I think we will, for the first several months, be dealing with the pandemic as we have for the last year. And, that will create some challenges. We've figured it out to a large degree, but we haven't gotten all the way back to normal. And then the other issue that I think will cause things to kick off a little bit slowly is there will be some time before the new leaders in the new administration are in place. Again, I think we are still much to learn about where that's going. But during the time before the leaders come into place, often I think the agencies tend to be a little bit cautious. And that, again, you won't see the new agenda come in until the new leaders come in. What do you think, Ilene?
I agree with you. I don't think we're going to see major changes. I think they're going to take their time and make sure they investigate where they think they want to investigate. in general, I do think we'll have more investigations into what I'll call the moderately concentrated marketplaces, just to understand it. And as we said, any place where the word platform comes up, the more vertical. I don't know if we'll see more actions brought. I don't know whether parties are going to want to call the question. I don't know how many commissioners there are going to be on the FTC and when we get more commissioners in there. So all those I don't knows are reasons why things will move slower. And we haven't also talked about whether there will be changes in legislation that might be the most would cause the greatest alteration of how you look at these things in my entire career, if some of what has been suggested by Senator Klobuchar goes into place. But those are not things that are going to necessarily come into play until late 2021 or early 2022, I would think. I might be surprised. Who knows? Anyone who thinks they can figure out what's going on in Congress is better than I am at this point.
Ilene, I think it's fair to say it's an uncertain time for many companies, for many industries, and as you've highlighted, an increasingly complex and unpredictable regulatory environment. So, Ilene, before we let you go, we're coming towards the end of our episode here. We like to ask all of our guests a few questions. The first is to tell us something interesting about yourself that we wouldn't know about you if we just knew you professionally.
My husband and I have collected contemporary glass for the last 35 years, and I spend some of my time on pro bono activities helping artists and museums who specialize in this area to keep the interest in the media going.
Glass, interesting. What's your favorite glass sculpture
that I own?
That you own or that's out there?
They're different. Probably my favorite glass sculpture I own is a Chihuly chandelier that my husband and I commissioned for our 30th wedding anniversary. And every morning when I go down the stairs and I go into my dining room, I look at it and I just think how gorgeous it is. And I think of my 30 some odd years collecting with my husband.
How strictly enforced is the no playing ball in the Gotts house rule applied?
Even down to how strictly enforced is it when do I have parties and let people put their pocketbooks down near where they might get near glass? I'll just leave it. My stress level goes up quite a bit when I have people around who are not used to being around glass. My kids were always very careful because they grew up knowing you do not touch. You can look, but you do not touch. Somehow there are adults out there that haven't yet caught on to that.
And in my household, if something breaks, we often blame the dog. Just so you know.
Even my dogs. Well, when we got the new dogs, I got really worried because they're two from the same litter, and they do tend to go and they spend a lot of the times wrestling each other, that sort of thing. Like now they're like teenagers, and they do worry me. And I immediately will say, "Stop it!" And I say it sternly, and they look at me and go, "Oh, mommy's here," and they freeze.
They know too, right? They've been trained well.
They've been trained, and then it's like, "Oh, we forgot for a second, Mom, but yeah, you're going to tell me you're not going to give me a treat tonight if you keep this up."
we may need you to come down to our house and work with our dog. That's not
you got to get past the pandemic. I'm not traveling before then.
And Ilene, what advice do you have for students or younger lawyers looking to do what you do?
Get involved in the ABA, Antitrust section. My best friends in the world are there. You will find it's a very generous bar. No matter how old, how young, everyone helps everyone. It's wonderful.
We are nice to each other. And I think it's probably in part because you never know when you're going to end up. We're all repeat players with one another.
Yes.
So you never know when you're going to end up, if you're on the opposite side, when you're going to end up on the same side, if you're doing a deal, when you're going to be doing the deal together, when you're going to be back in front of the regulator. And so it's a real mistake not to be nice to one another.
And nice does not mean that you don't zealously and go and try to protect your client's interests.
Sure.
But it's how you do it. You're ethical, you're open, etc. But you still have to do what's in your client's interest.
Great. So Eileen, now it's our last segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So Eileen, I'm going to ask you, we have a virtual Curious Hat, and I'm going to ask you to pick a number 1 through 25.
18.
18. Shuffling through my pages. Okay. What is an accomplishment you are most proud of?
Good question. I think it's a really good question. I really think having been the chair of the Antitrust section and what we achieved, that was 2009-10, year of the Great Recession. And despite that, and we also had volcanic ash that devastated my spring meeting. But despite that, we all had fun and we achieved a lot.
And is there anything? Oh, go ahead, John.
No, I was just going to say, Eileen, I remember you testifying in Congress that year, and we held it together. That was a tough year, man, and we held it together. Despite that, I remember the one meeting was in Half Moon Bay in California, if I'm not mistaken, yes. and then Miami, and like I said, it was a tough year for people, but we held it. Things held together, and you did get a lot done. I'm just thinking, we had Harvey Saperstein. That year I decided, instead of paying a speaker at the dinner we do for the spring meeting, that I would get Joel Klein, who had just finished being the chancellor of the schools, talk a little bit about the role of education, how important it is. I took the money that usually goes to that, and I went to Harvey Saperstein and I said, I want you to put together some consumer-oriented videos that we could go into inner city schools and help train, provide them there, make it amusing for the students. And we did one on basically warranties, and we did one on lending and some of these other things. Not cyberbullying, it was bullying itself. And you can picture Harvey, who just passed away, who really had one of the best senses of humor and can do. He did it. We put together this great series. And I remember just thinking about that as I was at his memorial service 3 weeks ago.
Well, everyone, you heard it here on Our Curious Amalgam. Join the ABA Antitrust Law section. It's where you make longtime friends, and that's certainly been true for me as well. So thanks again, Eileen, for joining us today, and thanks all for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.